Case Law Number 06/2016 AL, on the case of dispute on inheritance. Including 5 parts: Part 1, Source of the Case Law; Part 2, Overview of the Case Law; Part 3, Content of the Case; Part 4, Assessment of the Court; Part 5, Rules. This case law was adopted by the Judicial Council of the Supreme People's Court on April 6, 2016 and promulgated under Decision No. 220 QDCA dated April 6, 2017 by the Chief Justice of the Supreme People's Court. Cassation Decision No. 100/2013 GDTDS dated August 12, 2013 of the Judicial Council of the Supreme People's Court on case of dispute on inheritance in Hanoi between the plaintiff, Vu Din Hung, the defendant, Ms. Vu T Tin, also known as Hien, Ms. Vu T Hao. Persons with related rights and obligations are Mr. Vu Din Duong, Ms. Vu T Cam, Ms. Vu T Tao, Ms. Nguyen T Kim On, and Ms. Ha Thuy Lin. Part 2, Overview of the Case Law. Case law situation regarding the dispute on estate, in the case where the heirs reside abroad, if the court has requested judicial entrustment and gathered evidence in accordance with law, but still cannot determine their residence. Legal resolution: the court must still resolve the request of the plaintiff, if it is possible to determine the estate and the class in the line of succession, and there is no will, the resolution of the division of the estate for the plaintiff will be carried out in accordance with law. The parts of the inheritance belonging to the absent heirs shall be temporarily managed by the heirs residing in Vietnam and later handed over to the absent heirs. Key words of the case law: disputes on inheritance, heirs residing abroad with unknown residence, judicial entrustment, division of estate, management of estate. Part 3. Content of the case. In the Statement of Claims dated July 2007, Mr. Vu Din Hung is the plaintiff presented as follows. His parents being Mr. Vu Din Quang and Ms. Nguyen T then had 6 children, including Mr. Duong, Ms. Cam, Ms. Tao, Mr. Hung, Ms. Tin, Ms. Hao. Mr. Quang and Ms. then had a house of 123 square meters at number 66 Dong Xian Street, Hon Kien District, Hanoi. In 1979, Mr. Quang passed away without leaving a will. Ms. then and her 3 children being Mr. Hung, Ms. Hao, and Ms. Tin lived in the house. Mr. Duong, Ms. Tao, and Ms. Cam went abroad. In the minutes of the family meeting dated October 28, 1982, Ms. then, himself, Mr. Hung, Ms. Tin, and Ms. Hao agreed to temporarily divide the house into 3 parts for himself, Ms. Hao and Ms. Tin to use. In 1987, Ms. then passed away. In 1989, Ms. Tin secretly sold to Ms. Nguyen T Kim On her part of the house that was temporarily divided. When he initiated a lawsuit requesting the court to divide the estate, on October 31, 1993, Ms. Hao continued to sell to Ms. Ha Thuy Lin her part of the house that was temporarily divided. The sale and purchase of the house was wrong. Mr. Hung confirmed that his 3 siblings residing abroad, Mr. Duong, Ms. Cam, and Ms. Tao, had written documents to gift to him their parts of the inheritance, so he requested the court to divide their parents' estate in accordance with law. Mr. Hung presented copies of the powers of attorney dated March 3, 1992 of Mr. Vu Din Duong, dated May 1, 1993 of Ms. Vu T Cam, and dated October 28, 1991 of Ms. Vu T Tao with contents to authorize for Mr. Hung to manage and watch over their parts of the asset being 1/6 of the house located at number 66 Dong Xian. After submitting the statement of claims, Mr. Hung presented additional documents comprising letter of assignment of the inheritance right dated April 25, 1995 of Mr. Vu Din Duong, letter of assignment of the inheritance right dated May 10, 1995 of Ms. Vu T Cam, and letter of gift of the inheritance right of Ms. Vu T Tao. The aforesaid documents stated that they were made in abroad and had the contents confirming that the parents had left the house at number 66 Dong Xian for the 6 children. However, Ms. Tin, also known as Hien, and Ms. Hao had sold parts of the house that their parents left for them, which disobeyed their parents' instructions. They must not sell and must not let outsiders reside. Mr. Duong, Ms. Tao, and Ms. Cam had gifted to Mr. Hung their parts of the inheritance, each being to 1/6 of the house at number 66 Dong Xian, for him to maintain a place for ancestor worship, and also for 3 families residing abroad to visit and worship the ancestors. Also, they are suggested that Mr. Hung be entitled to the asset. Documents presented by Mr. Hung were just photocopies. The defendants presented, Ms. Vu T Tin presented, she confirmed the consanguinity and the origin of the house number 66 Dong Xian as presented by Mr. Hung. In 1989, Ms. Own sold her part of the inheritance, handed over the house and completed procedures for the sale and purchase of the house to the buyer at the Land and Housing Department in Hanoi. Upon moving into the house, Ms. Own agreed with Mr. Hung and Ms. Hao on exchange some construction works in the house for the convenient use by the parties. Afterward, Mr. Hung submitted a complaint and thus the Land and Housing Department revoked the dossier for sale and purchase of the house between her and Ms. Own. She asserted that Ms. then had already given money to the 3 people who went abroad, so they had no request regarding the house. She had already sold her part of the house to Ms. Own, therefore, she had no responsibility with respect to the already sold part of the house. Ms. Vu T Hao presented, she confirmed the consanguinity and the origin of the house number 66 Dong Xian as presented by Mr. Hung. She also confirmed the division of the house and the sale of Ms. Tin's part of the house as presented by Ms. Tin. She asserted that she did notify her siblings abroad and obtained their consents when selling her part of the house. She requested the court to divide the estate, allocating to her the part of the house that she sold to Ms. Lin and Mr. Koi. The persons with related rights and obligations presented, Ms. Ha Tui Lin, Mr. Hong Man Koi, Ms. LUient T Kim On. The wife and husband Ms. Ha Tui Lin and Mr. Hong Man Koi presented, when they bought the house, Ms. Hao did show them the minutes of the family meeting, so they both agreed to buy. They paid in full, moved into the house, and have lived there since then. They request the court to legitimate the part of the house already bought from Ms. Hao. Ms. LUient T Kim On presented, on October 18, 1992, she bought the house that Ms. Tin was given, with the price of 30 million dong. The transaction was permitted by governmental authorities. Upon purchasing the house, she moved into the house and agreed with Mr. Hung to exchange certain areas of the house. She requested the court to recognize the sale and purchase agreement of the house between Ms. Tin and her. In first instance civil judgment number 20 DSST dated May 23, 1995, the People's Court of Hanoi ruled to accept the request of Mr. Duong, Ms. Cam, Ms. Tao represented by Mr. Hung and Mr. Hung to divide the estate of Mr. Kwong and Ms. Then, to accept a part of the will established on October 28, 1982, to determine the estate to be about VND 1,228,151,520, to divide the estate in kind being the house and land for 3 people being Mr. Hung, Ms. Hao, and Ms. Tin. The sales and purchases between Ms. Tin and Ms. Own and between Ms. Hao and Ms. Lin were carried out in accordance with government regulation. Mr. Hung submitted appealed on the reason that the court was not objective. Ms. Teen submitted an appeal and requested a review of the calculate method for the area of the estate. In Appellate Civil Judgment No. 115 dated October 10, 1995, the Appellate Court of the Supreme People's Court in Hanoi ruled to set aside the first instance judgment, to transfer the case to the People's Court in Hanoi to reconduct first instance procedures. In first instance civil judgment No. 50 DSST dated September 11, 1996, the People's Court of Hanoi ruled to accept the request of Mr. Hung, Mr. Duong, Ms. Cam, and Ms. Tao, who was represented by Mr. Hung for the division of the estate of Mr. Kwong and Ms. Then. To recognize the voluntary gifts of the parts of the estate from Mr. Duong, Ms. Cam and Ms. Tao residing abroad to Mr. Hung, and to divide the estate in kind for Mr. Hung, Ms. Hao and Ms. Teen, each person is entitled to 1/3 of the store and a part of the back of the house. Ms. Hao and Ms. Teen must pay the difference to Mr. Hung. Ms. Hao's payment of VND 156,824,381, Ms. Teen's payment of VND 140,774,106, transactions of the house between Ms. Teen and Ms. Owen and between Ms. Hao and Ms. Lin were unlawful. Mr. Hung submitted an appeal. In decision number 82 TDC dated July 15, 1997, the Appellate Court of the Supreme People's Court in Hanoi ruled to temporarily suspend the resolution of the case. Upon resolution number 1037/2006 NQ-UBTVQH11 dated July 27, 2006 of the Standing Committee of the National Assembly on Civil Transactions established before July 1, 1991 on houses, in which there is a party being an overseas Vietnamese, the Appellate Court of the Supreme People's Court in Hanoi resumed resolution of the case. In Appellate Civil Judgment No. 142/2007 DSPT dated July 3, 2007, the Appellate Court of the Supreme People's Court in Hanoi set aside and transferred the case to the People's Court in Hanoi to reconduct the first instance procedures with the finding that the statement of claims was written and signed by only Mr. Hung, the powers of attorney of Mr. Duong, Ms. Tao, and Ms. Cam also do not express the authorization to initiate a lawsuit for division of the estate, except for Ms. Tao's power of attorney. At the present, the involved parties acknowledge that Mr. Duong and Ms. Tao have passed away, therefore, it is necessary to verify these facts and involve their heirs in the litigation to re-evaluate the land and home accordingly. After re-accepting jurisdiction over the case, the involved parties presented, Mr. Duong and Ms. Tao passed away around 2002. The first instance court requested Mr. Hung to provide death certificates of Mr. Duong and Ms. Tao, to supplement the statement of claims in accordance with Article 164.2 of the Civil Procedure Code, full name, address, nationality of Mr. Duong's and Ms. Tao's children, name, address of the person living on the land attached to a house in dispute, but Mr. Hung could not provide. In decision number 04/2008 QDS-TDS dated on January 17, 2008, the People's Court of Hanoi suspended the resolution of the case and returned advance cost fees to Mr. Hung. On January 29, 2008, Mr. Hung submitted an appeal on the grounds that the court's suspension of the resolution of the case was incorrect. In decision number 168/2008 DSQDPT dated September 4, 2008, the Appellate Court of the Supreme People's Court in Hanoi accepted the appeal of Mr. Hung and set aside the first instance decision on the grounds that the first instance court applying Article 192.2 to suspend the resolution of the case was incorrect, which deprived the involved parties the right to litigate. After re-accepting jurisdiction over the case, the People's Court of Hanoi requested Mr. Hung to provide documents being name, age, address of the heirs of Mr. Duong and Mr. Tao, written authorization or waivers of inheritance of such people, name and address of people residing on the Ms. Own's property, however, Mr. Hung could not provide the aforementioned documents. In Decision Number 54 DSST dated September 30, 2009, the People's Court of Hanoi ruled to suspend the resolution of the case on the division of the estate, to return the petition, attached documents and evidence to Mr. Hung. Mr. Hung submitted an appeal. In Decision Number 44 2010 QDPT dated March 9, 2010, the Appellate Court of the Supreme People's Court in Hanoi ruled to uphold the first instance decision. Mr. Hung submitted a request for cassation procedure. In Decision Number 35 2013 KNDS dated January 22, 2013, the Chief Justice of the Supreme People's Court protested against Decision Number 44 2010 QDPT dated March 9, 2010 of the Appellate Court of the Supreme People's Court in Hanoi, requested the Judicial Council of the Supreme People's Court to review the case under the cassation procedure. Set aside the above-mentioned appellate civil decision, and set aside the first instance decision on the suspension of resolution of civil case number 54/2009 DSST dated September 30, 2009 of the People's Court of Hanoi, transferred the case to the People's Court of Hanoi to reconduct first instance procedure in accordance with law. In the cassation hearing, the representative of the Supreme People's Procuracy unanimously agreed with the protest of the Chief Justice of the Supreme People's Court. Part 4. Assessment of the Court. The Judicial Council of the Supreme People's Court finds House number 66 Dong Xian Street, Hon Kin District, Hanoi was built by Mr. Vu Din Quang, passed away in 1979, and Ms. Nguyen T then, passed away in 1987. They had 6 children consisting of 3 children being Mr. Vu Din Duong, Ms. Vu T Cam, Ms. Vu T Tao residing abroad since 1979 and 3 other children being Mr. Vu Din Hung, Ms. Vu T Tien, also known as Hien, and Ms. Vu T Hao residing in Vietnam. After Mr. Quang had passed away, only Ms. Then, Mr. Hung, Ms. Tien, and Ms. Hao managed the house. Upon Ms. Then passing away, Mr. Hung, Ms. Tien, and Ms. Hao divided the house into 3 parts for their residence. Since October 18, 1992, Ms. Tien sold her part of the house to Ms. Nguyen T Kim On, and on October 31, 1993, Ms. Hao sold her part of the house to Ms. Ha Tui Lin. In 1993, Mr. Hung initiated a lawsuit requesting the division of the above-mentioned estate including the land and house of his parents in accordance with law. The resolution of the case lasted from 1993 to 1996, and was suspended in the appellate hearing in 1997. In 2007, the jurisdiction over the case was re-accepted. When resolving the case, before the period of temporary suspension, 1997, Mr. Hung had provided petitions and powers of attorney established in 1991, 1992, 1993, and 1994 of Mr. Duong, Ms. Cam, and Ms. Tao with the content of assigning to Mr. Hung to watch over their parts of the estate being the land and house number 66 Dong Xian Street. Later on, Mr. Hung again provided documents established in 1995 of Mr. Duong, Ms. Tao, and Ms. Cam with the content of gifting Mr. Hung their parts of the estate in dispute. Documents stamped and sealed in their home countries, Mr. Duong residing in England, Ms. Cam residing in France, and Ms. Tao residing in the United States, were just photocopies. Nevertheless, the involved parties clearly stated the house number and addresses of drafter. In the process of re-accepting jurisdiction over the case after its temporary suspension, Mr. Hung, Ms. Tien, and Ms. Hao stated that Mr. Duong and Ms. Tao passed away around 2002. Mr. Hung also asserted that addresses of Ms. Cam and Ms. Tao were unchanged, and he also contacted Mr. Duong's children but did not receive any reply. Records number 376, 377, 382. The first instance court requested Mr. Hung to provide death certificates of Mr. Duong and Ms. Tao, name, and address of the children of Mr. Duong and Ms. Tao. Mr. Hung presented that he could not provide the above-mentioned documents, and requested the court to gather evidence to resolve the case in accordance with law, record number 390. Therefore, the dossier contained the addresses of people who resided abroad, and the court's request for Mr. Hung to provide death certificates of Mr. Duong and Ms. Tao was unnecessary, because 3 people in Vietnam confirmed that Ms. Tao and Mr. Duong had passed away. The first instance court should have requested judicial entrustment in accordance with law, collected evidence with respect to Mr. Duong and Ms. Tao to clarify the time of their deaths, and in the case where they have heirs, obtained the heirs' opinions on the resolution of the case. Depend on each situation on the collection of evidence, the case will be resolved in accordance with law. In the case where the court cannot collect any further evidence, the Mr. Hung's request to be entitled to inherit under the law must still be settled. Parts of the estate belonging to Mr. Duong and Ms. Tao shall temporarily be handed over to people residing in Vietnam to manage, so that later on their heirs can receive such parts in accordance with the law. By doing so, the case will be entirely resolved. As for the people who are residing in the part of the house purchased from Ms. Teen, Mr. Teen is obliged to provide their names and ages. The first instance court requesting Mr. Hung to provide the names and ages of the aforementioned people was incorrect. The first instance court ruled to suspend the resolution of the case on the ground that Mr. Hung could not provide the names and the addresses of the people who bought the house from Ms. Own and of the children of Mr. Duong and Ms. Tao was incorrect. The appellate court should have set aside the first instance decision and transferred the case to the first instance court for resettlement as opposed to upholding the first instance judgment is incorrect. In addition, subject to documents contained in the dossier and the testimony of Mr. Hong Man Koi on October 17, 2007, record number 373, and the agreement for sale of a house dated October 31, 1993, record number 18, Ms. Howe sold the part of the house under her management to Ms. Ha Tui Lin. Ms. Lin's husband is Mr. Hong Man Koi. Therefore, the name LUient T Tui Lin stated in first instance and appellate decisions was inaccurate and needed to be amended properly. For the above reasons, pursuant to Article 297.3 and Article 299 of the Civil Procedure Code, Part 5, Rules. 1. To set aside Decision Number 44/2010 QDPT dated March 9, 2010 of the Appellate Court of the Supreme People's Court in Hanoi and decision on suspension of resolution of the case number 54/2009 DSST dated September 30, 2009 of the People's Court of Hanoi. 2. To transfer the case to the People's Court of Hanoi to reconduct first instance procedures in accordance with law. Content of the case law. The first instance court should have requested judicial entrustment in accordance with law, collected evidence with respect to Mr. Duong and Ms. Tao to clarify the time of their deaths, and in the case where they have heirs, obtained the heirs' opinions on the resolution of the case. Depend on each situation on the collection of evidence, the case will be resolved in accordance with law. In the case where the court cannot collect any further evidence, the Mr. Hung's request to be entitled to inherit under the law must still be settled. The appellate court should have set aside the first instance decision and transferred the case to the first instance court for resettlement as opposed to upholding the first instance judgment is incorrect. The first instance court requesting Mr. Hung to provide the names and ages of the aforementioned people was incorrect. The first instance court ruled to suspend the resolution of the case on the ground that Mr. Hung could not provide the names and the addresses of the people who bought the house from Ms. Own and of the children of Mr. Duong and Ms. Tao was incorrect. The appellate court should have set aside the first instance decision and transferred the case to the first instance court for resettlement as opposed to upholding the first instance judgment is incorrect.